Good morning, good afternoon to you. I will share my experience as a member of the Committee on the Elimination of all Forms of Racial Discrimination. And it's very important to talk about the International Convention for the Elimination of all Forms of Racial Discrimination and the body that is in charge of, we can say, in charge of be vigilant that everything is going to be accomplished. And I just wanted to share with you some personal experience. When I was lobbying in the United Nations in the 80s and the 90s, I didn't know the importance of the treaty bodies. But when I learned it, I started to put more attention and learned that many of the treaty bodies can help to defend the rights of indigenous people, especially the ICERD and CERD. And that is why I am delighted to share with you some of the important issues on ICERD and CERD. Why? Because human rights are based on non-discrimination. That is very important. And I just wanted to read you very slowly one of the paragraphs of the Preamble Universal Declaration of Human Rights that was adopted in 1948. And it said, whereas recognitions of the inherent dignity of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. So taking this in account, I think that the struggle against racism is very important to understand, especially for indigenous people. Because in the 50s and the 60s, when they were decolonization in Africa, and the decolonization start, they found that the colonization, the base of the colonization was racism. And many people thought that racism was only white against black. And that's why when the decolonization almost finished in Africa, and of course, the discussion of racism started, many people thought that racism was ended. That's why over the decades, the struggle against racism and racial discrimination at the United Nations has been closely linked to anti-colonialism and the struggle of self-determination. And today, I can add it, self-determination of indigenous peoples. And it was very strange seeing that as we have moved forward in the eradication of racism, we have also seen the practice and manifestation of racism becoming more sophisticated in practice and difficult to identify. Personally, sometimes I say that the practice of racism is starting to be cynically, because you know that today, well, before racism was violent. Now, of course, today we can see some violence that some racist group are committing against minorities in some countries, but especially in general, you are not going to see more violence against minorities or against indigenous peoples. And that's why sometimes I am saying that the practice of racism has been not only sophisticated, but also cynical practices. That you can find that and you experience that if you have traveled. When you travel to some European countries, some countries who are so-called developed countries, immediately they are going to stop, even that they are saying that this is a random, they use a random system to ask questions to some people, but it's very, is very, or it calls the attention when you see that the random system only takes some people who have different physical aspect, and they are not white. They are not representing the majority of those countries that you are visiting. So that's why I believe that it's very important to take this and to see all those situations, because racism is one act that you cannot prove. So that's why in the act you have to be very careful to see all the situation that is surrounding the action that is taking probably against you or against another person. You know that the practice of racism, and you will see in my slideshow that I sent to Project Access, that there are some houses that is showing how indigenous people are living. Some cases you will see that probably you are going to say, but that is not racism. Yes, it's racism, because surrounding those houses, you are going to see beautiful houses which are not from indigenous people. And now I'm talking about only indigenous people. And so, especially in some countries, third world countries, you will see that the indigenous people are living in a very, we can say, sad conditions, because instead to have the condition that the rest of the population, they are living sometimes in a difficult time, even some more difficult than third world countries. That is very difficult to understand. So, and the international community is starting to discuss how to prevent racism and racial discrimination. In 1965, they started to discuss on this, and the United Nations adopted the International Convention on the Elimination of all forms of racial discrimination. It's the first of the 9 major human rights treaty bodies which was adopted by the United Nations and entered into effect the January 4th, 1969. Why it took 4 years to enter in effect? Because in the body of the convention, it said that it has to have a certain number of states adopted, signing, and take it as a part of their legislation to enter into effect. So it was until the 4th of January of 1969 that the numbers of a state that was a member of the convention, and that's why it's starting or enter into effect. In 1969, also, the Committee for the Elimination of Racial Discrimination, as everybody knows, ICERD, entered into action also. Was the first human rights treaty to establish a compliance monitoring system for the state parties. That is very important. And I wanted to emphasize that was the first body, the first convention, because even some members of, I'm sorry to say this, but some members of the United Nations believe that this is the civil and political, international civil and political covenant that was the first. No, it's the Convention of the Elimination of Racial Discrimination, and also the committee that was the first body that was established in the United Nations. The ICERD is the first legal binding international convention. Especially for indigenous peoples today, this instrument was what is needed, because had almost all the rights of indigenous people recognized in only one instrument. And I will recommend to you to read and to study Article number 5. I have a very close friend that was we can say my mentor, my teacher in the United Nations system. Mr. Augusto Williamson Diaz, that he was saying, look, in the convention, in the International Convention for the Elimination of all forms of racial discrimination, you will find in Article 5 a supermarket of human rights that defend the indigenous people's rights. Why? Because as you are going to see, Article number 1, Article number 2, Article number 4, they are talking about the struggle against racism and the struggle against apartheid. But Article number 5, the members or the representative of state who were discussing this, they were very clever to put all the rights in Article number 5. You will see the list of all human rights in Article 5. That is very important that you study, that you learn about Article 5 of the Convention. As I was saying, the ICERD plays an important role in the fight against all forms of racial discrimination because it creates state obligations with respect to racial justice that are legally binding for all signatories. A state not like Canada, just to make an example, and another 166 states which have ratified the convention are state parties and are legally bound to comply with these provisions. And I think that these numbers is changing every day. I believe that today are 182 state members of the convention. And I think it's the second convention that was more ratification that had this convention in this moment. So the ICERD does not, or the another issue that is very important to tell you is that ICERD, or the Convention for the Elimination of All Forms of Racial Discrimination, doesn't or does not distinguish between intentionally discriminatory acts and those that have discriminatory effects. What this means. You know that the action directly for racism sometimes are insults, sometimes are violence, sometimes is, well, but somebody can hit you only because you are an indigenous person. But it's more difficult to see those actions that have those discriminatory effects. And those are the laws, the decrees that are taking place in some states, that or some policies of the states that they are trying to launch in a national level. So you have to study all those projects that the state are presenting to you, to study and to see if that project is not going to affect you as a person, but also your people as a community, because those are the acts that have a discriminatory effects, and that is very important that this convention is taken in account. So ICERD provides a legal framework that indigenous people, NGOs, communities, and human rights activists can use to bring attention to racial discrimination by a state. And provides also an official process to present alternative information for periodic reviews of state compliance. Any state that has been adopted the convention and is member of the convention has the duty, has the obligation to present their first report 1 year after they adopted the convention. And after that, it's going to be every 2 years, but the committee is the one who is going to tell the state how long time they have to present their next periodic report. The ICERD defines racial discrimination in a broad terms, and for not confusing, I will read it to you, this definition. And it said, in this convention, the term racial discrimination shall mean any distinction, exclusion, restriction, or preference based on race, color, descent, or national ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedom in the political, economic, social, cultural, or any other field of public life. It's Article 1 of ICERD. It's very important that you learn this article of the convention, because there is give you all the elements how to define and how to identify also racism in your own country. So the treaty monitoring body for the ICERD is a CERD, Committee for the Elimination of Racial Discrimination. And as I was explaining, it's composed by 18 international experts nominated by the state and voted on by the state parties to the convention, or they call the General Assembly of the Convention of ICERD, and assess state parties' compliance with the provision of ICERD through regularly scheduled periodic reviews. And this periodic review is very important that you have in mind that you can participate also as a member of the delegation of the government, but also as an NGO or as indigenous people. You can present also your information. You can give the information to the government, but if you see that in the report, the national report or the official report doesn't reflect what you have give to them, you can present also your report to the committee. And so many people, they call shadow report, parallel report, but it's the same. You can send your report to the committee. So the committee provides mechanisms for input by civil society, including indigenous people. CER is the only UN treaty body, monitoring body with indigenous expert member was. I was the only indigenous member of the indigenous, of all treaty bodies. So in this moment, there are not indigenous person in any treaty bodies. So I was honored, but also it was a big responsibility to be the only indigenous person to be part of the treaty body. The committee had many ways to recommend to the state how to act. Is the interpretation of the committee, how the state has to interpret also each article of the convention. These are produced by CERD to provide interpretation on the content of ICERD articles and can be used in thematic topics. Although they are not legally binding, general recommendations carry considerable weight and are meant to guide a state party as to their obligation under the convention. And for example, Article 29, 2002, it said, concluding, the fresh effort need to be made as well as existing effort intensified at the level of domestic law and practice to eliminate the scourge of the descent-based discrimination and empower communities affected by it. So that is one of the recommendations of the committee to interpret the one of article of the convention, and also recommend the state to establish a statutory mechanism through the strengthening of existing institutions or the creation of specialized institution to promote respect for the equal human rights of members of the descent-based community. There is a recommendation especially for indigenous peoples, and this recommendation number 23, General Recommendation 23, that was adopted by the committee in 1997. As you will see, this is very important because it was before, 10 years before the adoption of the Declaration of the Indigenous Peoples' Rights, and affirms free, prior, and informed consent. General Recommendation 23 calls upon states to, in paragraph 4, subparagraph D, ensure that members of indigenous people have equal rights in respect of effective participation in public life, and that no decision directly relating to their rights and interests are taken without their informed consent. And also right to land and resources, that is very important. The committee especially calls upon state parties to recognize and to protect the rights of indigenous people to own, develop, control, and use their communal land, territories, and resources, and where they have been deprived of their land and territory traditionally owned or otherwise inhabited or used without their free and informed consent, to take steps to return those lands and territories. For me, this is the soul of the interpretation of the convention. And when CER review a state, as I was explaining before, the civil society, indigenous people can participate. The committee makes recommendations, final recommendations to the state for improving policies, programs to combat racism and address racial discrimination which violate the provisions of ICERD. CERD recommends are not made public until it's informed to the state what is going to be the recommendation. After the committee received replies from the government of the state, is when the committee made public the final recommendation to the state. Why do submission to CER? If you don't inform CER members, they won't know the true situation between the state that it will be reviewed. That's why it's very important. And the committee also, it said, for us, civil society, indigenous people organizations are very important for our work. And that's why the Committee of the Racial Discrimination have a non-informal meeting with civil society and indigenous people organization in the lunchtime. It's about 2 hours of meeting, which you can submit oral presentation, but you can also add the writing testimony to the committee to give them more information about what is happening in your community. It requires the state to be more honest with CERD. It defines indigenous struggle as a human rights issue. It helps to educate people and community about human rights in international bodies. It creates international pressure on a state to respect human rights. It challenges state impunity and confronts hypocrisy because many states are coming to the committee and the first thing that they said, we are not racist, we don't discriminate, we are not practicing racism against our people. But when the committee started to ask questions, when committee started to say, look, we receive information from this or the other or NGOs, they started to explain their behavior. So that's why it's very important for you to send information to the committee. It can result in real change and improvement. I can share you many positive things that have been happening. Probably it needs more. There are small changes. For example, the Western Shoshone present an urgent action to the committee. We decide to adopt one recommendation to the United States of America. After that communication, or after that decision was taken, some of the work in the Western Shoshone territory stopped. And the companies that were doing that work in the Western Shoshone territory, they were not willing to be called racist for the action that they were taking there. And the shadow report, as I was saying, is very important. There are not any format that you can send, but I can tell you that it's better if you can send a report no more than 20 pages, because there are too much information that the committee is receiving that sometimes if you are going to send 100 pages, it's going to be impossible for the members of the committee to read. It's very important also when you send a report to send a summary, one-page summary of what is talking about your report. If one expert is going to be interested reading your summary, be sure that he or she is going to read all the report and all the annexes that you are going to send in the report. So that is very important for you. There are other opportunities for making submission to CERD, not only a shadow report. You can use also early warning procedure. When you are reading some law that is going to affect the right of indigenous people, you can send a petition to the committee as an early warning procedure and explain it that this law is going to affect the life of indigenous people or is going to have a very racist effect on indigenous people. And if you explain that, and the committee is going to study the situation, and is going to communicate in an early warning procedure to the state. But if the action has taken place already, there is another procedure which is urgent action procedure. Urgent action procedure, we can say, follow the situation for not increasing the human rights violation of indigenous peoples. So that means that one act already took place. And urgent action procedure is because that action was already taken. And what is the meaning of the urgent action procedure is to stop the violation of the right of indigenous people. There is another way also, individual communication. This is a little bit more complicated because the state has to make a declaration of accepting the competence of the committee under Article 14. And Article 14 is communication of individual. There are many steps that you have to follow. First, you have to exhaust all the national measures, legal measures that you have. If you have exhausted that, you have to explain that you have exhausted, and that's why you are sending individual communication. And sometimes the committee make an exception, and it's because the committee is going to study that already you don't need to exhaust those national measures because you explain in your petition that is going to be it's not going to result in anything, and so that's why you are sending directly the individual communication to the committee. But you have to be very clear that this communication has to be under Article 14, and the state has to make the declaration of accepting the competence of the committee. If you don't, if the state have not done this declaration, you cannot send individual communication. You can send it in urgent action procedure. From 2010 to today, probably 9 of 10 early warning submissions were from indigenous people opposing, especially mining in their territories. It's very important that you see in my PowerPoint 2 examples. One is the Western Shoshone, and the other one is one case in Guatemala. It's very important because you will see that the Committee of Against the Racial Discrimination is very interest on the situation of the indigenous people rights. Other issue that indigenous people have been used also the early warning or the urgent action procedure. And it's because treaty violation and extinguish of land resources right, denial of due process and free prior for consent, discrimination, criminal justice and court system, disproportionate violence against indigenous women, removal of children and racism in education, destructions of sacred sites and cultural discrimination, environmental racism, and other violation by the state party to the convention. And you will ask what is environmental racism? That has been starting to use in the committee because the one who was starting to use it was the Western Shoshone case, because they were saying, look, they continue their activity because it's in our land, because we are indigenous peoples. And that's why they don't care. And what we are seeing is that is environmental racism. When many organizations learn that terminology, they continue using that terminology. Another example is a garbage dump that was used in Chile, and the Mapuche started to use also environmental racism. Finally, they stopped the dump of garbage to their territory, and that is another example of the work of the committee. The ICERD is very important body between the United Nations. At least that is something that I believe that can help indigenous people and civil society to protect the rights. The ICERD and ICERD are important tools for the struggle to combat racism and discrimination to gain equality in exercising our rights and to assert and defend our human rights as a people and as individuals. And I hope that I share the experience that I have with you. I thank Project Access, UNDP, to allowing me to address you, and thank you very much.